Welcome to our presentation. Today we're going to be covering topics controlled by Circular 230. Our goal is to hopefully get you to the point that you won't get into problems, that you'll avoid them by being able to identify issues which can create problems for a practitioner, and to take steps when you do see a potential ethical violation to assure it doesn't occur. So with that, let's move on to our next slide. I'm Bob McKenzie. I concentrate my practice in representing clients before the IRS and state agencies. All I do is representation. I do not do any tax returns preparation. I do advise occasionally on tax positions on returns, but I do not prepare returns. But one of the other things I do is represent practitioners who get into trouble with the Office of Professional Responsibility of the IRS and various state agencies that could be disciplining a CPA. So as part of that, I've had to defend people who've made mistakes or allegedly made mistakes. Again, that gives me an understanding of the way the Office of Professional Responsibility administers Circular 230, and hopefully by having done this, I can give you some insight as to what people have done to cause them to become under scrutiny from the Office of Professional Responsibility. So with that, let's jump to our next slide. And some of the things we're going to cover will be the newest standards and penalties for tax preparers, specifically preparer penalties, and also standards within Circular 230 when you're preparing a tax return, and your duties of due diligence, your duties to assure that you're doing the best quality work. We'll discuss new provisions of Circular 230, relatively new provisions. They were latest revisions were 2014, but some of you may not have seen them, and even if you did, this is a refresher on those. Some of the other topics that are very important and have caused practitioners to get into trouble, in my experience, are potential conflicts of interest, correction of taxpayer mistakes, and that can include where the taxpayer presents and you review prior returns that were prepared by another preparer and you find problems. It also could include where you missed something while doing, for example, the 2016 return, and it only comes to your attention when you begin to do the 2017 return. What are your duties? And we'll cover that. Unconscionable fees, return of a client's records, what taxpayer confidences may you disclose to the IRS. So we'll try to get into each of these as we go through this. Some news. Management at the Office of Professional Responsibility, which is known as OPR, changed in August of 2015. For several years before that time, we had Karen Hawkins in the position, and she was previously a practitioner out of Oakland, California, as an attorney who represented people before the IRS. So she came to the job with the experience of somebody who'd actually been representing people for over 30 years. Our current director is a government career employee and may have a different perspective on his job than that of Ms. Hawkins, who was his predecessor. Steve Whitlock was previously the director of the office, the whistleblower office of the IRS, which had been around for about 10 years after passage of legislation in 2006 by Congress, providing for awards to whistleblowers who ratted out other taxpayers. Now, one of the things that has generated more and more actions by the Office of Professional Responsibility is that the IRS has created an official complaint form against tax preparers. And that was created about 5 years ago. And the reason it was created is they had instructions on how to complain about a allegedly bad tax preparer on the Office of Professional Responsibility site, but taxpayers rarely looked at that. But what has occurred is they created an official form, the 14157, and it allows the taxpayer to file a written complaint in a specific format and against a preparer. Now, each of these complaints go into not the OPR, but the Return Preparer Office. So, to distinguish that, the Office of Professional Responsibility is the disciplinary arm. The RPO, the Return Preparer Office, is in charge of doing multiple things. It administers the enrolled agents test. It issues the return preparer numbers, and it also reviews complaints that come in regarding preparers. And so the taxpayer will submit this complaint to the RPO. They'll review it to see if there is some violation of rules at the IRS. And after review, if they think that there's a violation of Circular 230 by the practitioner, it will be forwarded to the OPR, the Office of Professional Responsibility. What the importance of this form is that before the creation of the form 5 years ago, there was rarely any complaints filed when the taxpayer had to search out how to complain about a preparer. Since the implementation of this form, the IRS is getting thousands of complaints each year. Now, some of the complaints have specific merit. For example, my preparer was given accurate information by me, but when the return was prepared, he took extra deductions that I didn't spot until later. I authorized electronic filing of my return. It was filed, and for whatever reason, the practitioner added on additional deductions or took expenses I wasn't entitled to. Something like that would certainly be a type of matter that would be looked at and referred over to the Return Preparer Office. On the flip side, the majority of the complaints don't have merit. They'll have complaints like, last year H&R Block charged me $400 for my return, and this year my CPA that I hired charged me $800. He's cheating me. And those types of things don't go to the Office of Professional Responsibility. They're just essentially determined not to be actionable. There also will be, in the case of a paid preparer who is not an enrolled agent, CPA, or attorney, there may be referrals to the Department of Justice for action, since the Office of Professional Responsibility only has authority to discipline those of us who are enrolled agents, attorneys, or CPAs. I come under two of those categories. I'm an attorney and I'm also an enrolled agent. So I'm subject to discipline by the Office of Professional Responsibility, but unenrolled preparers are not. So bottom line, because of this new complaint form, thousands of complaints arrive with the IRS each year. They sort through those complaints, and a certain percentage of those complaints end up with a referral for potential discipline to the OPR. Now, when a practitioner becomes subject to OPR discipline, he or she certainly has rights to defend against those complaints, and one of the things I do for a living is to defend those accused by the OPR of doing something improper. Another form that is generating a lot more complaints is the Paid Preparer's Due Diligence Checklist. Now, you have a due diligence requirement under the Circular 230. It states that when you're preparing a return, you're under a duty to exercise due diligence in preparation of that return. Now, what really places you at risk is if you do a return that includes either the EITC credit, the American Opportunity Tax Credit, the Child Tax Credit, or additional child tax credit. you are subject to discipline if you don't do the checklist form 8867. And what I've seen and what I've defended over the past several years is practitioners, first of all, who failed to do the due diligence checklist when appropriate. And that failure can cause you to end up with an investigation by the IRS and a referral to the Office of Professional Responsibility for your failure to exercise due diligence by doing a required form. Now, the other thing that I've had, though, to defend is where the person did the form, but the IRS argued as to the quality of follow-up questions that the person asked after doing the form. I defended one practitioner where the IRS alleged and asserted preparer penalties against that preparer on 80 separate returns, alleging that when he did the 8867, when there was something that was ambiguous in the taxpayer's answer, there were no notes as to whether the practitioner did follow-up questions. Now, my practitioner assured me that he had in fact asked follow-up questions when appropriate, but because of the rush of filing season, he didn't make extensive notes on the form 8867. We were forced to go to an appeal after the revenue agent refused to accept our explanations, and we did settle that, and my client did avoid the danger of being penalized and potentially disciplined. Another one I've defended is my practitioner had the policy that he would prepare returns, and in the case of paper returns, he had an assistant to assemble them and put them together for the taxpayer to mail to the IRS, and the practitioner then could busy himself solely with the duty of preparing the returns and not worry about assembling them. His problem was that he had not properly trained his assistant, and his assistant would do the return package for the client, put the 8867 in the file of the taxpayer with the practitioner, but would not staple the 8867 as part of the returns. And so the IRS arrived alleging that as a paid preparer, he had not completed the due diligence checklist in the case of a huge number of returns. We were able to show that there was an EITC form in each taxpayer's file that had been completed, but unfortunately the taxpayer was not given that form to be submitted to the IRS. And again, we had to negotiate over a substantial period of time to keep the taxpayer preparer from being penalized by the IRS. Again, because you're under a duty under Circular 230 for due diligence, a checklist that says paid preparers due diligence fits right within that definition, and the failure to do that checklist puts you in danger of being disciplined for failure to comply with the rules of Circular 230. Now, the IRS at various times has announced its priorities in looking at practitioners, and priorities that have been discussed in various forms and text publications by IRS, both by the Return Preparer Office and the OPR, are 1. Conflicts, 2. Whether in soliciting business, in our advertisements, in our websites, we are complying with the ethical rules and we are accurately representing what we can do, and then we are not using puffery or misrepresentations in our assertions of our qualifications and what we can accomplish for a taxpayer. And then lastly, an emphasis that began under Ms. Hawkins and has been more of an emphasis in the past than in the past, even after her departure from the OPR, has been when tax practitioners do not provide quality service. And that could be within the realm of preparation, it could be in the realm of tax advice, or it could be in the realm of representing the taxpayer. So each of these have been a priority by the IRS discipline authorities, and I'm going to discuss them in a little more depth now.